Morning. Call the list. Yes. Admitted contractual bill? Admitted? So they admit. Then why are you not making the payments? If this is admitted, then what instruction? Then you have to make payments. How can these payments not be paid? This is pending since 2019. This is not done. Absolutely not done. They have successfully completed their work. You cannot keep them hanging like this. These are legitimate dues. Whatever reasons ABC it may be. It is your duty to give to release the payments. You cannot keep it withhold. If required, this court will impose interest. It cannot be done like this. Yes. So I'm keeping this on Friday. Wednesday then. Kaile Wednesday. Tomorrow then. You have the information. Tomorrow. This matter will not be kept hanging. Mr. A. Bhattacharya, Learned Standing Counsel, Revenue, shall obtain instruction as regards the time frame within which the subject payments due to the petitioner shall be released. Stop. Positively, stop. List this matter tomorrow. You see, you just have the information. You can have it through WhatsApp. Give us a time frame, and this court will dispose of this matter. This matter cannot be kept pending like this. It is not correct. 1 to 5. Yes. Needless to clarify that the instructions sought shall be positively placed be placed on the next date of listing, failing which this matter shall be proceeded in accordance with law. I have made my mind clear, so have it tomorrow.
Will not apply, rather it will be section 31. Section 20 and 29 of the State Financial Corporation Act.
Will not apply.
Will not apply, it will be section 31. Why? Because it is when the property belongs to the mortgagor or the surety.
Section 31
will apply.
Yes.
State Financial Corporation Act. And I have also placed a decision of the apex court also, I think it is on record, 2008.
This court will go to the decision, but first, what is the fact?
Yes, my lord. Fact is very
nothing.
Fact
Can you clarify the facts?
Yes, my lord. Fact is that, my lord, on 6/4/2013, my lord. A simple fact.
That decision that you are saying you are relying,
2005, my lord,
is not on record.
I have given a photocopy, my lord.
Second copy to. No, it's not
I
here.
have.
By Supreme Court decision as
I have another copy.
No, it's not there. Mr. Bora, you are appearing.
My lord,
You have filed your affidavit.
I have filed the affidavit, my lord. But in the meantime, the decision has come. Decision has come.
In the meantime,
There is a decision of this affected court, not only these multiple reasons of this affected court. The section 29 applies to the principal board. Section 29 doesn't apply to the.
so here the question is, the petitioner is a
I'm the Bora.
yeah, Bora. So therefore, section 29 is not applicable.
The land has been taken under section 29. Section 31 applies to the petitioner, being a board.
So then,
In this case, it will be section 31 because.
so then what is to be done?
Well, Lordship will cause the into notice, madam, but liberty will be given to the Financial Corporation to proceed according to law. Whether it is section 31 or surfacing.
And now, the decision which you are also relying is
No,
this.
I am not. My friend is relying on the decision.
That is the decision. 2008 5 SSC.
Yes, ma'am. There are other decisions also, but
This
it
is
is
along the same line, madam.
along the same line.
Same line.
Section 29 will not apply
So
to
then,
the mortgage.
without going into the merit of this case, I may simply say disposed of in line of the decision of the apex court and so and so,
liberty to the financial-
and liberty to the financial corporation to proceed in accordance with
According
law.
to-
Is that is that all right? Yes. Heard so and so, hindi diba. It is submitted at the bar that the issue involved in this writ petition is squarely covered by the decision of the apex court in the case of Karnataka State Financial Corporation versus N. Narasimha and others, reported in 2008 volume 5 SSC at page 176. Stop. In view, next paragraph, in view of the aforesaid endorsement, this writ petition is disposed of in the similar lines of the aforesaid case. Stop. Needless to clarify that the respondents are at liberty to proceed in accordance with law, comma, if they so desire. Anything else?
My lord, this order may be
Resultantly, তার উপর দিব দে, needless to clarify উপর দিব. Resultantly,
taking out question 7.
page,
My lord, page 39.
no, prayer, it must be there in the prayer.
Yes, my lord. Yes, page 32 and page 30. Oh, in the prayer, my lord. Yes, my prayer is at page.
Which is the order to be set aside?
I'm asking for the order, my lord. Annexure G and Annexure H. Annexure G is the notice, and Annexure H is the taking over that notice.
Page 38 and 39.
38 and 39, my lord.
Resultantly, the takeover notice dated 6/11/2019 within bracket Annexure G
G.
and
My lord, and this notice of actual taking over person on 7.
that is 7/11
7/11.
and the
Annexure H.
taking over possession of the mortgage property of the guarantor and hypothecated assets of Messrs. Richa Rice Mill on 7/11/2019 in exercise of jurisdiction under Section 29 of the State Financial Corporation Act 1951 are hereby set aside and quashed. Disposed of.
Most of it.
Aparna, এইটো decisionটো মই ইয়াত এটা লাইন পিছত এড কৰি দিম ফাইলটো দি দিবা.
Meet is the matter pertains to payment of compensation, my lord.
Yes.
An affidavit would be required, perhaps, my lord.
My lord, I am appearing on behalf of 234. Okay, 2 and 3 is the National Highway Authority of India. That is, we are not constructing regarding 2 and 3, we have filed affidavit to that effect, but we are not constructing agency. Regarding 4 also I am appearing. I will be filing affidavit to the other secretary.
All right.
4 weeks time may be granted.
Mr.
On behalf
Talwar?
of 4.
All right. So you also file.
Yes.
As prayed for by Mr. C.
C. Borua.
Borua, learned
Standing Council NHIDCL.
Standing Council, NHIDCL, within bracket, respondent number 4.
4.
And B.J. Talukdar, learned additional senior government advocate for the state respondent number 5 and 6, comma, list this matter after 2 weeks to enable the respondents to file their respective affidavit in opposition in the matter.
My lord, may I pay for at least team
3 weeks করে দিব
pilot.
আপনার।
Yeah.
Apply.
তুমি দিগদাৰ পোৱা নাই না ঠিক আছে
Met with alert. Alert, this is second time alert bail application. Earlier order alert rejected by your lordship, my lord. At that point of time, my lord, 164 statement of the victim was not available.
you have it now
Yes, my lord. And
yes it is in English
yes. It was recorded, my lord, before consideration of the bail petition earlier occasion. No, 164 statement was recorded recently, my lord, after rejection of the bail application. No. I have, my lord,
Mr. Counsel, would you let this court go through the material placed by the APP?
my lord.
Why are you getting so impatient? You are Kalamuddin.
Salam.
There is no implication
No
as
implicating
such.
material. Otherwise, my lord, admittedly, victim is, my lord, minor.
Huh?
Victim is minor, my lord.
Victim is minor.
Minor.
But anyway,
Yes.
let him appear then.
Yes, yes.
You want to say something, Mr.
No.
Borbhuya?
No.
Heard Mr.
AM बोल दिया.
A.M. Borbhuya, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for the state respondent. Stop. This is an application under section 438 CRPC seeking granting anticipatory bail in favor of the accused petitioner I. MD Abdul Kalam Borbhuya, LS MD Joinal Uddin Borbhuya, LS Kalam Uddin Borbhuya, who is apprehending arrest in connection with Hailakandi PS case number 283 of 2023, registered under section 366 IPC, corresponding to GR case number 1230 of 2023. Stop. Pertinent that by order dated 31/3/2024, this court had earlier rejected the prayer of the anticipatory bail of the petitioner. Stop. Today, when the matter has been called, don't say when the matter. Today, Mr. P. Borthakur, learned APP for the state respondent, places the case diary, which includes the statement of the victim recorded under section 164 CRPC, on 2/3/2024, which was earlier not available
Earlier not available.
while considering the first anticipatory bail application filed by the petitioner. Stop. Upon perusal, next para, upon perusal of the aforesaid deposition of the victim recorded under section 164 CRPC, it appears that there is no the victim has not implicated the petitioner for the offence alleged. Stop. In view of the aforesaid, this court is of the considered view that custodial interrogation of the petitioner may not be justified for the ongoing investigation. Stop. Accordingly, the petitioner, in the event of arrest of the petitioner named above for the aforementioned case, shall be released on a bail bond of rupees What 30,000 is not implicated?
Yes.
10,000 to the satisfaction of the arresting authority, subject of course to the following conditions. Number 1, appear 10 days. 2, 3, disposed of. Condition kita jane na? Disposed of. And return case diary.
Blood.
You ask Vidika.
Earlier also on 17/5 none appeared on behalf of petitioner.
That is an anticipatory bail.
Thank you.
Anything in the case diary?
Otherwise, well, in the case diary, there is no such material against the present. Why he is approached before the SEBI, my lord? Till now, my lord, from the case diary, there is no such incriminating material against.
Nothing is there.
It is up to my lord.
None appears for the petitioner when called. It appears that on the last occasion, i.e. 17/5/2024 also, there was no representation on behalf of the petitioner. Stop. This is an application under section 438 of CRPC seeking pre-arrest bail to the petitioner, i.e. Sri Hiteshwar Das, who is apprehending arrest in connection with Chanmari PS case number 48 of 2024, registered under section 120B, 143, 384, 354 capital A, 354 capital C, 506 IPC, within bracket, corresponding to GR case number 1125 of 2024. Stop. The brief facts of the prosecution case is that on 27/2/2024, one Binita Nath lodged a FIR with the officer in charge, Chanmari Police Station, alleging inter alia therein that paragraph 3 at page 2, the quoted portion to us, till paragraph 3. Stop. Mr. P. Borthakur, learned APP, for the state respondent fairly submits that there are no incriminating materials available in the CD.
It is up to my lord 22/4.
In the CD, CD, stop. In view of the aforesaid submission and in view of the aforesaid submission and upon perusal of the materials available in the case diary, comma, this court is of the considered view that further custodial interrogation is not justified for the ongoing investigation. Stop. Accordingly, 30,000 kuripila released. Hey, aga order to condition 10 days. The only thing is that how will the petitioner know?
Yes, but
The advocate is not there.
earlier also not appeared.
Let registry inform the petitioner as regards the passing of the order,
The petitioner's counsel phone number is there.
and also to the advocate appearing on behalf of the petitioner.
That is there for hearing.
Yes, Dr. Saraf, Mr. Sharma had already finished his part of the argument on the last occasion.
Before I start my submissions, first of all, I express my apology for not being able to
No problem, Mr. Dr.
appear
Saraf.
on the last day. Similarly, I am very sorry that Mr. Sharma, who is the intervener, he was making the arguments. My lord, the intervener has no role to make the arguments. He can either support or either petitioner or the respondent. He being not allowed to implead as a party respondent, I've never heard of that the intervener is making the submissions as a party respondent, and the
All right.
and the party respondent is adopting the arguments.
All right. No, Doctor, Mr. Gogoi has
I have
also
not
argued.
No, he has,
I have my individual
please,
argument.
I have seen the recording. I've seen the recording of that day.
All right.
Who argued and who has not argued. So, my lord, it is very unfortunate, in fact, I must say, that, and it was not a case, my lord, that the petitioner is not appearing before your lordship. So, the respondent, by any means, has to argue first. Whenever the cases are listed before lordship, my lord, I always, my lord, whenever is available, I am arguing the case. Generally, my lord, the lordship give the
Dr.
hearing-
Saraf, this being a matter pertaining to 2019,
Actually,
and since the
maybe, my lord, but,
advocate has also come,
my
on
lord,
the
the advocate
way,
is coming for a
therefore,
number of days, and first of all,
we
I
have
also
heard, but that doesn't mean
Well,
it's
my submission,
concluded.
my
Yes.
submission is different. My
You,
submission
you are not required to reply to their argument. You
No,
go
no,
ahead
my
and make
submission-
your
my
submissions.
submission is
If
altogether
anything is
different,
required, we'll go back to the
My,
hearing.
I will come.
Yes.
My submission is
I
altogether
have
different.
noted that you are saying the intervener has no locus to.
He will be heard. There is no doubt about it.
But the main, it is the state respondents.
My lord, lordship may kindly see me, before I take lordship, because it's my duty to that what is the intention of the intervener. You must, lordship must note that what is the intention behind of the intervener. My lord, under the BIS scheme, it is the authorities who have to decide whether certain things are to be marked as BIS or not. Intervener and another domestic company submitted a representation before the authorities that these two items must be marked as BIS. Now, two reasons mainly in the representation about the quality of the goods which are imported. Now, if the quality of the goods being imported, then it becomes a PIL. Somebody is aggrieved that poor quality of the goods are being imported, somebody may file a PIL. This is not a PIL. The reason what is there, my lord, your lordship must pierce the veil and see that what is the reason behind making it compulsory BIS marking.
Yes.
Well, earlier, they filed a complaint before the designated authority in the anti-dumping duty, my lord.
Before the.
Designated authority under the anti-dumping law that on the import of phenyl and melamine, my lord, anti-dumping duty should be imposed because the import from whichever is there, that is in the lower prices and that is affecting the domestic industry. The domestic industry is being affected because of the import of these items from outside India, which is at a lesser prices than the normal prices. Ultimately, at the designated authority, by an order, found that no, this is not correct. Earlier it imposed, but subsequently said that no anti-dumping duty will be imposed on these items. When they found that the anti-dumping duty is not imposed and import will be there, they came up with recommendation that now BIS should be marked. The reason is only that to see that these goods are not imported from outside, so that the demand of the goods in India from the domestic producers, because there are two domestic producers, so far I know, by the Pancake Life, they will supply the goods at the prices they want and thereby earn huge profits. In one of the representations, they have said clearly that because of the import of these items from outside, the domestic industries are affected. Whenever in other items below, the BIS marking was done, and not at all that the poor quality of goods could come.
Yes.
The prices of the said goods in India has doubled because the goods are not available, less quantity is there, demand is more, the prices go. So the interest of the intervener is only to see that there is a scarcity of the item in India and the manufacturers of plywood, etc., they are forced to purchase the goods from the domestic industry, and the domestic industry in turn will charge the prices whatever is in their interest is there, and thereby earn huge profits.
Phenol, you are purchasing it from outside.
So I am purchasing from outside. Now BIS marking, Your Lordship, normally nobody can say that BIS marking should not be there, poor quality of goods should be there. Here the provision is there that the person who is exporting, he must get registered with the BIS authorities by paying $10,000 for registration.
So even a person from outside can get its concern registered under the
Absolutely.
BSI.
Absolutely.
So
Now,
there is no, as such, there cannot be a restriction then. If a
I
BSI
am submitting that what restriction in what way. Well, these are not the items which are packed items. They come in tankers in the ship. They are unloaded and taken to the manufacturing unit. Now, BIS marking, I will take a lot of provision. One is health hazard, deceptive or unfair trade practice for purpose of BIS marking, and health hazard to the consumers or the general stakeholders. Now, phenol to consumers, which is used, is controlled by the drugs control
It
order.
is controlled by the?
Drugs control order.
Yes.
This phenol which is imported, melamine which is imported, is not for the consumers. This is for the purpose of manufacturing of the plywood. And as such, health hazards, when we say to the consumers, the question of the health hazard does not arise. They say that in one of the affidavits of the respondents, they have also added the word national security. I will try to explain also that how the melamine or the phenol which is imported from outside can have a national security issue. Now, consumers and other stakeholders, when we say Milord, then it means it is consumed by the general people, which is
When you are saying they said, you're referring to the intervener or you're referring to the reasons for...
both are the same at the same...
No, but here your challenge is to the BSI marking, right?
BS marking to
So
phenol.
on that, what is your ground?
Well, I'm coming to it.
Because according to you, this is done on the basis of the representation.
Yes, there is no doubt about it. They can say
that is why you are referring to the ground.
Okay. And that is why he is become an intervener.
Okay.
Now, my lord, there are many items like crude oil, which is coming from outside in the tankers. They are not consumed. They are used in the refineries for the purpose of refining of it. If it is so hazardous that even coming to the tankers, the people may be affected and all those things, it should be kept in a very, in such a manner. Then, when it is moving from the factory of the domestic producers to outside, it should be in such tankers that there is no health hazard. That is ISO marked tankers. When it is moving from the domestic industry to outside, there is no health hazard. But when it is coming from outside, then it is health hazard. Quality, if you say that quality is poor, then outside, health hazard will not reduce. Even if the item is better quality or lower quality, health hazard will remain the same about the item. It may be a health hazard when it is consumed, but not when it is used in the manufacture of the goods. Now, my learned friend, I think I could know that, my lord, that still the discussions are going on and no decision has been taken in the matter as yet. That is not correct. They have already framed the orders by notification. They have already said that it will come into force after 6 months. But because of interim order by this Honorable Court, that final decision should not be taken without leave of the court, and the Union of India has not come up before Lordship for seeking leave of the court. So it is not so that only discussions are going on and final decision has not been taken. I am just giving a preliminary before taking a Lordship,
Yes.
that whatever I could understand, my lord, after going through the recording nowadays is easier because there is no use of making notings. One can go through the recording. Third main ground which both the respondents are taking, that it is a policy decision, and as the Gujarat High Court has said, that since it is a policy decision, should not be interfered. The Lordship is very much aware that policy decision is not immune from judicial review, and I place the decision before Lordship that under certain circumstances, the judicial review can also be of the policy decision if it is irrational, if it is, my lord, arbitrary. Relative Article 14 of the Constitution of India, judicial review is permissible even in respect of the policy.
Yes.
I will be very short because on the last occasion I was directed to file the written submissions before Lordship. In fact, the written submissions, when when the matter came up before Justice Shyam, then Suman Shyam, my lord, Honorable.
This was earlier heard.
Yes, it was heard, my lord.
This matter is part heard earlier.
Not
but-
part heard because nowadays, after 3 months, my lord, the order is there that it should be. So, my lord, at that time we have already.
No, showing part heard before which bench?
No, it was earlier part heard, my lord. But now it is not part heard. So, there is no difficulty in that one. At that time, we were directed to file the written submissions and all of whatever judgments they are relying. Accordingly, we also filed, and my learned friend also filed it.
You have received a copy of the
Yes,
written
yes, we have
submissions
some.
filed by the other side?
Yes.
All right.
So, in fact, whatever submissions I have to make, I have already incorporated. I will just, in very short, my lord, I take your lordship. I will not trouble your lordship to the different, my lord, things. Lord, in fact, in the written submissions, whatever documents I have referred to, because there are so many affidavits, so many FNO opposition, and we have referred
The
to that.
size of the written submission is very.
My lord, when Mr. Sharma is on the other side,
Yes.
then, my lord, accordingly,
the
we have to be very careful.
weight of
and-
the written submission increases.
My lord. What I do for your lordship, my lord, convenience.
Yes.
So whatever documents have been referred to in the written submission,
Everything is
because
compiled here.
they are sometimes in the affidavit, some
Very well,
indefinite.
very
So I have prepared a, my lord,
Appreciated.
a compilation so that and referred to also that where it is referred and what documents are there.
My discovery this used to be there in Supreme Court earlier, but even Supreme Court today don't have this kind of.
Now we are much better than the Supreme Court
Very,
nowadays.
very nicely done. Madam.
You have to be mindful who is appearing the other side.
Absolutely. Madam, I should really compliment
Yes.
this team.
And also, my lord, the written submission also another, because you are seeing the color of the, you are seeing that shut down. So another compilation, I think we get.
This is what?
The written submission which you filed, my lord, so that you lost one green another
All
agreement.
right. So the thinner booklet is the written submission, and the other one is
Is the documents which
is
have
the
been referred to.
compilation of the relevant
which have been
documents.
referred to in the written submission.
All right. All right.
And the judgments, my lord, already have been given.
Judgments have been given by yours.
My lord, in the written submission earlier filed,
This one you are referring to?
my lord, written submission is mentioned the first item, written submission.
Yes.
Then the judgments are there.
So these are the judgments.
Right.
So if I have understood correctly, now you have handed over complete 3 sets of compilation.
Right.
One compilation of the relevant judgments, one compilation of the relevant documents, and other is your written submission.
Written
correct?
submission is already there, but for lordship convenience, I prepared it separately
All
so
right.
that
All right.
when your lordship looks into the documents, then it may
Yes.
be here.
You had, Mr. Sharma, last time I believe you had also handed over something, right?
There is another compiled judgment. I'll just hand over. The conductor is just asked that
No.
But how I will reply to that?
this everything whatever I said.
But we are not aware of the High Court, we are not from Supreme Court, we are not so.
No,
That's
no,
for-
you please give whatever you're relying to the other side. Don't give copies this side without handing over the other side.
No one. That's right.
Yes, Dr. Saraf.
So what happened, the Supreme Court, they are very much, my lord, by going to one side, they understand.
All right,
And
Dr.
our
Saraf.
knowledge is limited, my lord, it is difficult.
Yes, let us now focus to your case.
My lord, the General Agreement on Tariff and Trade, you will also find at page 182 of the writ petition, my lord.
Of the writ petition.
My lord.
One.
82.
পোষ্টিত দিবা নামেগা আকৌ এইকেইটা অকণমান হেৰি হৈ গৈছে এইটো এইটো ভাল লাগে এইটো থৈ দিয়া Yes.
And I take it also to page 188.
Yes.
Article 1, my lord. With respect to the custom duties and charges of any kind imposed on or in connection with the importation or exportation of imposed on the international transfer of the payments for imports and exports, and with respect to the method of levying such duties and charges, and respect to the all rules and formalities in connection with importation and exportation, and with respect to all matters referred to in paragraph 2 and 4 of Article 3, any advantages, favor, privilege, immunity granted by any contracting parties to other conduct originating or destined for any other country shall be accorded immediately and unconditionally to the like product originating in or destined for the territories of all other contracting parties. This is general tariff of the
Yes.
taxes, and thereafter lordship can see page 223.
Yes.
Article 20 mil.
Yes.
General exceptions. Page 223 mil. Subject to the requirement that such measures are not applied in a manner which would constitute a means of arbitrary and justifiable discrimination between countries where the same conditions prevail, or a restriction on the international trade, nothing in this agreement shall be constituted to prevent the adoption or enforcement by any contracting parties of measures necessary to protect public morals. Number 2.
What, Dr. Saraf, this
Fine.
Annexure 5 document is what? What is this document?
Below,
This Annexure 5 that you are relying.
this is general agreement of tariffs and trade.
No, who has
Well,
published?
this is adopted, accepted by the contracting parties.
This is adopted.
adopted.
All right. As per the Geneva Convention.
Well,
Yes, please.
page 223, Milo. Subject to the requirement that such measures
Yes,
are,
you've already read that.
no, Article 20, Milo, general exceptions,
Yes, yes.
223, Milo.
Yes.
Subject to the requirement that such measures are not applied in a manner which would constitute a means of arbitrary and unjustifiable discrimination between the countries where the same conditions prevail, or a disguised restriction on international trade commerce. Nothing in this agreement shall be constituted to prevent the adoption of enforcement by any of the contracting party of measures necessary to protect public morals. Number 2, necessary to protect human, animal, and plant life and health. 3, my lord, relating to the importation or exportation of goods or gold or silver, and necessary to secure compliance with the laws and regulations which are not inconsistent with the provisions of this agreement, including those relating to customs enforcement, the enforcement of monopolies operated in paragraph 4 of Article 2 and Article 17, the protection of the patent, trademarks, copyrights, and the prevention of the deceptive practices. Now, I will also may see I, my lord, H-I-J, my lord.
Yes.
Essential to the acquisition or distribution of the products in general or local source supply, provided that any such measures shall be consistent with the principle that all contracting parties are entitled to an equitable share of the international supply of such products, and that any such measures which are inconsistent with the other provisions of the agreement shall be discontinued as soon as the conditions giving rise to them have ceased to exist. The contracting parties shall review the need for the subparagraph not later than the 30th June, so and so. Now, below, the World Trade Organization, established in the year 1994 in pursuance to the Marrakesh Agreement, my lord, and India was one of the signatories of the 23 countries. Now, my lord, the agreement on technical barriers to trade entered to give effect to the objectives of the GATT, you will also find at page 284.
Yes.
And Lord Sumhali, my lord, having regard to the urgency around the multilateral trade of negotiations, desiring to further the objective of the GATT 1994. Thereafter, the second paragraph you will also skip over, and the third, my lord, desiring therefore to encourage the development of such international standards and conformity assessment terms, desiring, however, ensure that the technical regulations and standards, including packaging, marking, and labeling requirements and procedures for assessment of the conformity with technical regulations and standards, do not create unnecessary obstacles to international trade.
Yes.
Recognizing that no country should be prevented from taking measures necessary to ensure the quality of the export or for the protection of the human, animal, plant, life, health of the environment, and for the prevention of deceptive practices at the level it considers appropriate, subject to the requirement that they are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between the countries where the same conditions prevail, or a disguised restriction on international trade and are otherwise in accordance with the provisions of the agreement.
You're relying on this unnecessary, that restriction,
My lord.
that part.
Now, my lord, if somebody says that the goods which are imported are of poor quality,
Yes.
then some analysis or measures must have been taken to determine whether the quality of the goods are poor or not fitting to the standard. I will demonstrate to your lordship that in the RTI reply they have said that no such measures have been taken to analyze that what is the quality of the goods.
So there has been no assessment of the quality of the goods.
No. And in fact, I can tell your lordship that the quality of the goods purity of the goods which are imported from outside is better than the goods which are produced by the domestic industry.
So one of your argument is that based on the complaints, mechanically this has been
Well, I will
issued?
say that I will say, if you also may look to be harsh, to favor the domestic industry
without doing an assessment of the quality of the goods. And the other thing you are saying is that as per this treaty of which they are signatories, unnecessary obstacles should be avoided. And
Well, I
by-
can understand if after reaching the goods, they make an assessment of the goods, they find quality, throw it, destroy it. Don't allow in the port, from port to come outside. Make an examination. If you find that is below standard, don't allow it to come outside. Destroy it. But under the use of, I am asking a question to myself. You make a BIS examination there. You find, yes, it meets the standard. Subsequently, when the goods are dispatched, they are of not the same quality. How the objectives will be met? Unless and until you examine, simply putting the BIS marking is not sufficient. One lot you have examined, you have given a BIS marking. I declare that yes, it is a BIS marking. And there is no examination thereafter of the said goods. That what quality of goods are coming. Assuming 99.9% purity is required, that is examined, the BIS marking is given. Subsequently, when the goods are sent of the BIS marking, it is 98%. What examination is made of the goods? After all, the purpose is that it should be meet to the standard which is there. Whether there is any procedure of examining that the goods which are coming are of the standard which are within mark for BIS? The answer will be no. The domestic producers, when they produce the goods, they may be given BIS mark. Subsequently, when the goods are all coming, a declaration has to be given that yes, it meets the quality. Whether any instance is there, whether it has been examined.
All right.
Now we'll also make analysis page 285. Clause 2.2.
Yes.
Members shall ensure that the technical regulations are not prepared, adopted, or applied with a view to or with the effect of creating unnecessary obstacles on international trade. For this purpose, technical regulations shall not be more than trade restrictive than necessary to fulfill the legitimate objective, taking account of the risk non-fulfillment would create. Such legitimate objectives are inter alia national security requirements, the prevention of deceptive practices, protection of human health, of safety, animal, plant, or the health, or the environment. In assessing such risks, relevant elements of the consideration are inter alia available scientific and technical information, related processing, technology, or intended end users products.
What is, according to you, Dr. Saraf, the relevance of a BSI marking?
Below the quality of the goods for the consumers.
Yes, please.
Now, when we say ISI marking and all those things, like fame, like everything, which are consumed by the consumers. That's why when the crude oil is coming, it is not BIS marking.
Quality of what, sorry, Dr. Saraf, you've
For
said
consumers.
quality for the consumers.
Quality of the goods for the consumers. That the inferior quality of the goods should not be used by the consumers.
All right.
Now, these goods are not used by the consumers. These goods are used by the manufacturers. When we read the word, I will come to the act, my lord, consumers and other stakeholders, it will mean that somebody who is connected with the consumers. One is the consumer, another person who is connected with the supply of goods to the consumers.
Yes.
It will not imply a manufacturer who is using the goods for the manufacture of the goods.
But ultimately, after the manufacturer uses these goods, then is it not
Well, it
the
will be
end,
good.
end result? Is it
Well, I
not
will
the
submit.
use of the
I will
consumer?
The manufacturer, panel extra, is manufacture the plywood. The quality of the plywood, I can understand. You can put a ISA mark. That also is subject to it. But the like glue, like phenol, like melamine, which is used in the manufacture, it cannot be said that the poor quality has been used. It cannot be determined at all. Something can be determined which is capable of determination. Something is the finished product, you determine the quality.
But if a substandard ancillary thing is added to the final product, would it not ultimately cause
The final product will be determined.
compromise the quality of the final?
The final product will be determined whether what is the quality. What is to be determined that what is going to the consumer, if it is of the quality or not, if it is of the standard quality or not. If it is not of the standard quality, BIS mark will not be given.
All right. Yes.
Tomorrow in the hotel, my lord, assuming a given example, vegetables are served.
This example was coming to the mind of this court also about a food.
Now you can determine below the finished whatever products are there. Can you say that the vegetable which you purchased, that what was the vegetable used therein? It cannot.
No, but if the vegetable itself is stale, then the soup, the final
Then
product,
the final product will also be equally below.
it will be compromised.
The final product will compromise the final product. You have to examine the final product.
All
After all,
right. You
my
are
lord,
trying to make a distinction here.
my lord, if the used goods are of substandard, the final product will also be of the substandard quality. It cannot be said that they will not find out, they will not be able to find out the final product, because otherwise, how they will determine, my lord,
All right.
the final product, whether it is of the quality or not. So my submission is there, my lord, that the something which is impossible of, which is coming in the tankers, ships, in the ship, in the port. I say that you make my suggestion before Lord say that yes, before any goods moves from the domestic industries, well, factory also, let every tanker be examined. And every port, from port, whatever tankers are coming, before allowing them to go outside the port, every tanker should be examined. You see, I am giving the suggestion. If you are so interested that the quality of goods should go to the consumers, let it be done both in respect of the importers and both in respect of the domestic producers. If they are so hazardous, let it be made that they are carried in all ISO mark tankers, because it is so dangerous. It may affect the health. Let the domestic producers who are carrying the goods in the normal tankers,
All right.
because it seems that this is in the interest of in public interest. It may affect me, it may affect my learned friend, But ultimately, my lord, the issue is coming that the people should not suffer. Health,
Larger public.
up to the object is that the health should not suffer.
Right.
It should not affect the my lord, animal, plant, and all those things. For that, I will request that your lordship should take stern steps and give a direction to make it compulsory that before examination of the standard, they should neither come out of the factory nor from the port. I am importing, don't allow it. Examine it, if it's not of the standard, destroy it. Similarly, when the goods are coming from the domestic industry, if they are not of the standard which are by SPSMR, they should also be destroyed.
All right.
Now we'll also come to page 286, my lord.
Next page.
286, yes, my lord. Clause 2.7.
2.7.
My lord.
Yes.
Members shall give positive considerations to accepting as equivalent technical regulations of other members, even if these regulations differ from their own, provided they are satisfied that these regulations adequately fulfill the objectives of their own regulation. Now, my lord, the countries from where the goods are coming, they have also got their own conformity assessment regulations, which are much stricter than which is applicable in India. Because they are not only exporting to India,
Other countries also.
they are sending to other countries also. They will not manufacture only for India. They will manufacture for the different countries in the world. Now, can it be said that India is only, my lord, maintaining the standard, other countries are not maintaining the standard? It has to meet the conformity statement standard of that country. Without that, the goods cannot move.
All right.
Now, your lordship, can you see para 2.10? Subject to the provisions in the lead in the paragraph 9, where urgent problems of safety, health, environmental protection of national security raise or threaten or arise the members, that members unit such as the steps enumerated in paragraph 9 as it find necessary provide that the member upon adoption of such technical regulation shall notify immediately the members through the secretariat of the particular technical regulation and the products covered with a brief indication of the effective and the rationale of the technical regulation, including the nature of the urgent problems. Upon request, provided the members with copies of the technical regulations without discrimination, allow the members of the present with their comments in the writing, discuss these comments upon request and take these writing comments and results of their discussion to the account. If you find that certain things are, the quality is so and so, they must inform that this is a quality deficiency.
There's a procedure given.
My lord. And this is binding with the Supreme Court has said. Now, your lordship, may I see, my lord, the Bureau of Indian Standard at page 305.
Yes.
And the statement of objects and regions of this one, my lord, your lordship find in the compilation which I have given at page 28.
Compilation?
My lord, of the bound one, my lord, green one.
Yes, yes. Page 28.
My lord, it starts with page 28. At the relevant part, I will take your lordship to page 30.
Yes.
May I read you?
30.
Is 30.
30. Yes.
Well, the Bureau of Indian Standard 86 provides for establishment of Bureau of Indian Standard and for harmonious development of the activities of standardization, marking, and quality certification of the goods and process so as the BIS has formulated over 19,300 standards for about so-and-so products and services. The core activities of the BIR are statement, formulation, and certification of the articles and process under license. The BIS has the power to grant license to use standard mark under Section 10 of the BIS Mark. World Trade Organization Agreement on Technical Barriers in Trade encourages all members countries to adopt international standard and also move towards mutual recognition of the certification systems. WTO guidelines also provides that enforcement of the standards should have uniform application for both domestic industry and importing goods. In view of the increasing significance of the standard and conformity assessment system in world trade, it is essential that the BIS reorients itself in adequately address the future challenges of the national security of India. At present, BIS is not formally recognized by the National Standard Body of India, though it has been representing India in various international bodies. The BIS Act also does not provide the recall of substandard ISI mark products or marking of the previous metal articles, compounding of the offences, etc. provisions relating formulation of the standards and conformity processes also required to be aligned with the global best practices. Further, the State Act restricts the list of the items to those as referred to in the schedule to the industrial level so-and-so. In view of the increasing significance of the standards and conformity assessment system in the world trade and the address the aforesaid issues and future challenges in the area, comprehensive amendments are required to be made in so-and-so. Now I will take you to page 31.
Yes.
One of the objectives, my lord, to allow multiple types of conformity assessment schemes in tune with the global best practices.
Global best practices.
My lord. I will also see 8 at the bottom, my lord.
Yes, conformity assessment.
Conformity assessment scheme means a scheme relating to such goods, articles, process, system, or service as may be notified by the Bureau under Section 12.
Before that, I think 7 also will be
My
important.
lord. Conformity assessment means demonstration that requirements as may be specified relating to article, process, system, etc. to body are fulfilled.
Are fulfilled. And then the
consumer. Consumer means a person as defined in the Consumer Protection Act 1986. That has been now 2016 Act. Now we'll also see page 33.
Regulations.
Regulation means regulations made by the Bureau under this Act. Then I will take your lordship to page 38.
Yes.
Conformity assessment scheme, the Bureau may notify a specific or different conformity assessment scheme for goods, article, process, system, or service for any group or goods, articles, processes, systems, or services as the case may be with respect to any Indian standard or any other standard in a manner as may be specified by the regulation. 13 is the grant of license, my lord.
Yes.
A person may apply for a grant of license or certificate of conformity as the case may be if the goods, article, process, system, or service conforms to the Indian standard. Where any goods, article, process, system, service conforms to the standard, the Director General by order grant a certificate of conformity in the manner and as may be specified by the regulation. A license to use or apply a standard mark in a manner as may be specified by the regulation, subject to such conditions as payment of such fees, including late fees or fine, before doing the operation of the certificate of conformity, the license, and as may be determined by the regulation. Now 14.2, my lord.
Yes.
The goods or article notified in subsection 1 may be sold through retail outlets certified by the Bureau after such goods or articles have been assessed for conformity with the relevant standards for testing by the marking center. You will also find the retail centers.
AC to DDB. Are you feeling uncomfortable?
No.
You feel a fan can bohai jab.
So many of the retail outlet, which I was submitting before lordship to consumers, that retail outlet, here there is no sale of in the retail outlet. Now lordship see 3, the central government may, after consulting with the bureau by an order established or published in the official gazette, make it compulsory for the sellers of the goods or article notified in so and so to be sold only through certified sales outlets, fulfilling the conditions as may be determined by the regulation.
Yes.
The next page below 15,
Prohibition.
prohibition. No person shall import, distribute, sell, store, activate, or sell any goods
Refer
or-
to all these provisions in the written submissions.
My lord, that's in it. The person shall not import, will sell, store, exhibit, or sell any goods or articles under subsection 5 of section 14, except under certification from the bureau.
Yes.
Now the main important is section 16 at page 41.
So this is the certification,
My-
regulation 14.
My lord.
No, this is an act, right? Section 14.
My lord, and 16 is the direction by the central government. Here it is direction by the central government.
16. Yes.
Page 16, my lord.
Compulsory use of the mark.
My lord. It says the central government, if the central government is of opinion that it is necessary or expedient so to do in the public interest for the protection of human, animal, or public health, safety of the environment, prevention of the unfair trade practices, or national security, it may, after consulting the bureau by an order published in the official gazette, notify so and so. Now, what are the conditions, my lord? First is that, my lord, protection of human, animal, or plant health.
Number 1 is in the public interest
Public interest is necessary.
or for.
Public interest, my lord, says necessary public interest or for the. Now, public interest, your lordship will mean when it is or. Public interest is always when it is, your lordship will find that it is usually, your lord, when it is aided by the words.
It has to be read in
It has to be read in that line. Otherwise, the public interest
the context.
Public interest will never mean, my lord, that when we say, my lord, the detention is public interest. It must be for the purpose, some purpose.
All right.
And the purpose appears to be protection of human, animal, plant health, safety of the environment, or prevention of the unfair trade practices or national security. Now, my lord, as I submitted for lordship, the health of the animal, plant, etc. will not be there because this is directly goes to the, my lord, the manufacturing unit. This is not sold. Second is, my lord, that the environmental protection prevents the safety of the environment. My lord, I don't think that the phenol or the melamine which is imported from outside
All right.
has an
Even
environmental.
national security also may not be attractive.
National security in what way, my lord, the import of the phenol and, my lord, it is on the now
All right.
deceptive trade practices. They must explain that what is the deceptive trade
So
practices.
according to you, these
Preconditions
the conditions for compulsory marking are not there.
are not fulfilled at all. Because in the lawsuits find in WTO, very unfair trade practices. Now here it is used deceptive trade practices.
Okay.
Now deceptive trade practices is something illegal.
All right.
When you wanted to impose the anti-dumping duty on the ground that the goods which are imported from outside are coming at a price lower than the normal price, which is affecting a domestic industry, that is also not deceptive practice. Because the price at which outside is coming, it may affect the domestic industry, but that is not deceptive practice. That too, the legislative authority said that no, there is, well, the prices is to determine a particular way, that whether it is below dumping is there or not, they said there is no dumping and there is no way it can be said that anti-dumping duty can be imposed. So Lordship will find that same meaning has to be given to the deceptive trade practices or unfair trade practices.
All right.
Now we also may see the second one. We shall conform to the standard and direct the use of the standard mark under the
License.
license or certificate of conformity as compulsory on the goods, articles and process services. Thereafter, also may see explanation 2. It is hereby certified that the essential requirements are requirements expressed in terms of the parameters to be achieved or requirements of a standard or technical terms that effectively ensures that any good article, process, system or services meet the objective of health, safety and environment. Then prohibition to manufacture, sale of certain goods without standard marking. No person shall manufacture, import, distribute, sale, hire, lease or exhibit for sale. Now we'll also make kindly similar. No person shall manufacture. Manufacture which I am doing is plywood. I am not manufacturing phenol or melamine. Sell certain goods without standard, manufacture, import, distribute, sale, hire, lease, or exhibit for sale any goods, article, process, system under section 2 without standard marking solution. So certain things which are brought for the purpose of sale. That's why I submitted for lordship. It has to be read in the line of the consumers and other stakeholders.
Yes.
If it is not for the purpose of the sale, so that it may affect the consumers, in my humble submission, my lord, the RTI Act will not apply.
Yes.
My lord. Now, your lordship kindly see, my lord. Pagination करना है क्या?
Lupak.
Your lordship see page 177
Of this compilation.
compilation. It appears in my book the after 177 my lord, pagination is not there.
What is it dated?
177 your lordship see,
177, yes.
and thereafter next page my lord
Yes.
is the reply, and to that next page you are lordship see the RTI reply.
This 9th March is the application, isn't it?
My lord,
9th March,
that is my lord seeking RTI information.
that is the correct.
Next page my lord.
No, but what is this? This is given from the section
Ministry of
officer,
Chemicals.
the Ministry of Chemicals. The proposal for making BIS standard as mandatory for chemical is a policy and strategic matter. This is what you want to rely.
No, I have to reply my lord. Next page.
Next page. Yes.
One my lord. Whether any study was conducted, my lord.
Yes, yes.
Whether any study was conducted by the Department of Chemicals or Petrochemicals, or any report was received, or any complaint has been received by the department during the last 5 years in the matter of phenol melamine in the areas of public health, safety, environment, impact, etc. If so, copies of such reports and documents be provided. So, also we see the answer. There is no study has been conducted on phenol by this department. Information may be treated as nil.
All right.
So, no study was made with regard to the phenol and melamine in the areas of public health, safety, environmental impact, etc. It has been made clear that no. Thereafter, next may see, my lord, whether the request was received from so-and-so and so-and-so or any other entity conducting phenol and melamine in the country seeking any kind of protection. If so, the copies of the report be provided. The representations of so-and-so and so-and-so have been received and forwarded to BIS for their comments are enclosed. If one of them, my lord, my learned friend is appearing as interment.
Yes.
Whether the department has ever made any request for communication by letter, office notes, email, etc. with Ministry of Commerce, Directorate and Anti-Dumping of Director General of Trade during the last 5 years concerning so-and-so and so-and-so, and if so, the copies of such letters of communications may be provided, including the replies received from the respective directors authorities. Information may be treated as nil. Whether there is any proposal to consider or there was the proposal or there is a decision on these two products for BIS mandatory making recommendation for such marking, and if so, the copies of all those notes, etc. Department is working for making BIS standard as mandatory for major chemicals with consultation with the BIS.
Yes.
Now you also may see, this is the Department of Fertilizers and Commerce. Fertilizers. And this BIS marking does not come within the Ministry of Chemicals and Fertilizers. It comes within the Ministry of Commerce. In the written submission, I have mentioned it by giving that it comes within the Ministry of Commerce, not Ministry of Fertilizers.
Ministry of Commerce.
My lord.
Yes.
Next page, you will also see below. Whether any public representations have been received from public at large in the matter of BIS marking recommendation on these two products by the department, and if so, the copies of such representations so and so. Whether the public has made any complaint that the quality is so and so, then they say that only these two representations depend on the Deepak Phenol Limited dated so and so for regarding upgradation of the specific phenol necessary has been received. That is my learned friend intervened.
Yes.
Now we'll also
Mr.
find
Sharma is appearing for Deepak.
phenol.
I'm a
In the entire country,
So you are a manufacturer of phenol,
well, I am. I'm on BIS compliant.
and your you had filed representation that it should have the BIS marking. Correct.
I'm not clear, I will make it clear. When for the first time the BIS marking has been phenol that has been done, then in what way my learned friend is making submission that he is compliant of the BIS marking? So far I am not aware below. Perhaps he will explain, because it is only now they are going for making it BIS marking compulsory. So in what way? Prior to that, my learned friend is saying that it is compliant of the BIS. Now I will take a lordship to make short my written submission.
So in other words, what you are trying to bring home is that the domestic manufacturer of phenol is trying to get the BIS marking so as to ensure that the foreign phenol
Absolutely, my lord. We have given the representation
you
and
will be restricted, you cannot use, and you will be compelled to use the phenol produced by the respondent. This is in sum and substance.
otherwise in the
argument.
entire country of 140 crores.
How many more manufacturers are there?
I think one more, Gujarat.
Only two manufacturers
only.
in India.
Oh yes,
Only two.
only two.
You have stated that is that stated in the pleadings?
It must be
Anybody has
stated.
clarified.
I will verify.
Anyway, you can ask a junior to verify. You can
Petition.
point out later on.
You see, only two, my lord, I can say, because the last time
Is that an admitted position?
There are three manufacturers.
There are
Only
three
two are working now,
manufacturers. Three.
in the entire country. Now,
I would request one of you juniors to just give the names of the three companies.
what I was asking question myself, Lord, in a country of 140 crores, nobody has complained that of the inferior quality. Only a company which is manufacturing phenol is concerned and saying that the phenol which are manufactured and used by somebody else is of inferior quality. If the quality of the Leonard Prince company is better, naturally the people will use the better quality goods. How he should be concerned that inferior quality of the goods will never be used. Now, the purpose may not, if your lordship lift the bill, your lordship will find out. In my reply to the various representations, we have said clearly
Of course,
that
it appears prima facie, but the other thing is that at the end of the day, the authorities have taken a policy decision.
my lord,
Now, whether that can be faulted, and keeping in mind the limited jurisdiction that this court has, you are absolutely right, Dr. Saraf, that that policy decision is not immune.
my lord.
Certainly. In a-
Normally, your lordship will not interfere.
Absolutely, but in a given case where the irregularities and arbitrariness is apparent, manifest apparent, certainly this
Well, my
court
was
will-
asking question myself, you know, if they could have said that we have made a study, we found that this is the quality, inferior quality, this is not good. They said that no study has been made.
merely on the basis of a representation.
My lord.
Merely on the basis of the representation.
Now, unless and until you have made a study,
In their affidavit, they have explained anything, no?
no, nothing is developed. A study made nothing. In fact,
That
we,
they cannot go back. This
fact,
information
Lord, we have-
clarifies that position.
we have stated in our communications in so many words, giving details of our quality, everything, that what is the quality of the goods which we are manufacturing, importing, everything in detail we gave. But nobody has looked into it because the purpose is that
Where are those?
Milord, in the representations are all annexed, Milord. In the
Just give me the page numbers.
I will put the page number. Representation
From
number.
page
Century Private Liquidity was the page
such and such.
I'll
Just give me the.
I'll give. Now, nowhere, my lord, it says that we have made such and such quality assessment and your quality is not good, imported quality is not good.
All right, that is cleared.
Now I take your lordship to, without bothering, to your lordship may come to my written submission, my lord. Because in the line of the
So
Supreme Court,
right, it is at the recommendation stage that you had approached this court.
my lord, it was under the recommendation, thereafter the order has come.
Order has come.
My lord, I will give the page numbers. Take a look at it.
The recommendation has been given effect.
It has been given effect to my lord. I will show to your lordship. I may be wrong. You can correct it. You can correct it. There is no doubt about it. It are orders. Two orders have been notified for phenol and.
But those two orders are not put to challenge.
You know, that were subsequent one because this honorable court says that prior to taking a final decision, you approach this honorable court. And during the pendency of the petition,
They have.
they have passed the orders.
No, Dr. Saraf, those two orders have you brought on record by way of an
Yes, yes.
additional affidavit?
It is there.
Okay.
You know, just I will try to find out because I'm just mixing up. page 51 of my compilation, my lord. And page 52, your lordship.
But this is only saying that Department of Commerce is requested to forward comments, inputs of member states as and when received for further examination and necessary action in the department.
My lord, it says apply to goods and so conformity standard, page 52, my lord.
52. But this seems to be a draft. It seems to be a draft order.
For the purpose, my lord, because this honorable court says that no final decision should be taken without leave of the court.
All right, because this court's query was whether those recommendations have been put to effect. So it appears that it is still at the draft stage. It has not been finalized.
They cannot take a final decision because
there is an interim order of this court.
Yeah.
Can you point out the order?
Well, I'll give it.
Just give me the date.
First
I'll
date.
just
First
take a note
order,
here.
yes. First.
22nd of February 2020.
22 January.
2000.
Interim order.
I'll clarify the specific.
No, there is nothing to be clarified. This
No,
is,
but
anyway,
that draft notification is actually sent
but
to the
Mr.
government.
Sharma,
I will
I don't think this court you will get any more chances
Yes, yes.
because you took the risk and you have finished your arguments before the petitioner started.
Absolutely. I'll completely go down.
Only if anything is required, this court will
I
come
will
to
only
you.
assist the court.
Yes.
Well, my submission for lordship is that Union of India has not come up before lordship that we are taking final decision, kindly give us leave. Now from the pleadings and from the document it is clear that they are going ahead with the taking the phenol and the melamine as a compulsory PIS mark.
All right.
This was a 6 months period, your lordship can see. You have mentioned that it will be 6 months.
Anyway, this it's the entire that recommendation itself is under challenge.
My lord,
Yes.
when we are proceeding, my lord, that the proceedings for making the marking is illegal and without jurisdiction and not in conformity with the provisions of the Act and the object of making the BIS marking, then all subsequent proceedings, my lord, if the initiation itself is illegal, then as your lordship knows that
No,
subsequent
it's all right,
proceedings.
Dr. Saab, it's not finalized.
My lord,
It's in the draft stage, not finalized.
my lord. In the written submissions, if your lordship looks into, my lord, up to page 9, my lord, I've discussed about the WTO.
Yes.
Page 10, your lordship can
Why
see.
blank pages have been kept in the beginning?
So that your lordship may keep
Noting.
noting if necessary, my lord.
Yes.
I've given in the last page also blank for noting, my lord, so that
Yes.
lordship may see page 10, my lord. First of all, I have discussed about the BIS Act. And the last paragraph, my lord. It is therefore necessary to identify as to who is the consumer and who are the other stakeholders. The term consumer is defined in section 2(9) as a person defined in the, I think your lordship is writing,
I'll just come in 5 minutes.
my lord.
If you want to take a short break, both sides can take anything.
Looking into some papers and documents. In the petition, lordship may see page 94.
Page 94.
My lord.
Yes.
So let me say this is minutes office, minutes of the meeting held on so and so who are making BI standard for major chemicals as mandatory. Now I will take your lordship.
This is the minutes, I think, which is referred also in that reply to RTI
My lord.
in that chart.
First I will take your lordship what was there in page 99.
Yes. Page 99.
My lord.
Yes. Yes.
3, my lord.
Yes.
Panel.
I think you have pointed out this.
I have.
Yes.
You have pointed out the last paragraph also?
I think last paragraph.
Last paragraph of this
Yes, I
page?
have read the book. But you can read it.
Yes, I have to read it.
No, it only the second subpara of clause 3 was pointed out.
Last paragraph has not been read,
Yes, Dr. Saraf, you may place it.
my lord.
Yes.
I will read from second paragraph, my lord. The
Very well.
representative of the Federation of Indian Plywood and Panel Industry.
You are reading from just
Page
from where he
99,
had stopped, Mr.
Roman
Saraf.
3,
Yes.
the second paragraph, my lord.
Yes.
The representative of the Federation of Indian Plywood and Panel Industry stated the WTO TBT agreement states that the technical regulations should not be formulated to create obstacles in the international trade. Before formulating technical regulations, risk assessment regarding impurities present in the phenol, scientific and technical information may be collected and taken into consideration. Without risk assessment, powers under Section 16 of the BIS Act need not be exercised by the government. Further, they mention that the domestic industry of phenol is already protected from other countries by way of levy of anti-dumping duty. If further restrictions are imposed on phenol, the members may start importing phenol resin
So
directly.
risk assessment has to be done.
My lord, we say that risk assessment, etc., as I pointed out, my lord, that must be done.
Is to be done.
I will also say. The representative of the Indian Laminate Manufacturing Association informed that the laminated industry is a major consumer of phenol. Since availability of phenol is limited, their industry has to depend on imports. The Indian standards are very old and need to be revisited to match the international standard. So we said that you revisit it and make it in the international standard. Now what my learned friends, interveners said, the last paragraph. The representative of Deepak Phenol Limited informed the committee that to promote Make in India and to encourage import substitution, they have installed phenol plant of annual capacity of 2 lakh metric ton in investment of rupees 1,600 crore. 6 other countries, including Thailand, are exporting phenol in India at huge quantities at cheaper prices. They have to shut down their operations. They requested the committee to make the BI standard of phenol mandatory.
Yes.
Now this is the region.
Yes.
That they wanted, that it should be BIS marking, because not of the region of the quality. They have never said the quality. Here they are saying that we have in the under program Make in India, we have prepared so and so and such metric ton, and it has to be shut down. So import the BIS so that the import may not be there and the domestic industry may prosper, and they may be given a license to sell the goods at their own at the high prices. This is the reason behind which I was
Noted.
pressing before.
Noted.
Now we also see the written submission I was pressing for also page 11.
Page 10.
10 Miller.
Yes.
I'm sorry. Page 10, last paragraph I was reading below. It is therefore necessary to identify as who is the consumer and who are other stakeholders.
Last paragraph.
My lord.
Yes.
It is therefore necessary to identify as who is the consumer and who are the other stakeholders. The term consumer is defined in section so and so of the person as defined in the Consumer Protection Act. In the absence of any definition of the term other stakeholders, it would be reasonable to believe that other stakeholders mean and include such other persons who have an interest in the products under reference, that is the stakeholders in relation to the consumers acting as an intermediary in the trade of melamine and phenol in India, whose interest the measures seeks to protect. From a careful reading of the treaty and the Act of 2016 would show that while legislative objects of public health, safety and environment are common terms in both the TBT agreement and BIS, the TBT uses the term deceptive trade practices against unfair trade practices in the Municipal Act of 2016. The definition of the deceptive trade practice in international law and unfair trade practice in the Consumer Protection Act for the purpose of the present dispute are common to the extent it seeks to protect the interest of the consumers in India, the safeguard for which the Act of 2016 has been enacted. The unfair trade practices has to have some the same meaning as defined in the Consumer Protection Act to the extent it is applicable to the present dispute, that is, false representation that the goods are of a particular standard, quality, quantity, grade, composition and model.
This is what you are saying what unfair trade practice would mean.
My lord.
That is not the case here.
My lord. Deceptive and unfair trade practices.
So in that manner, the conditions prescribed in section 16 are not there.
My lord.
For which compulsory BIS marking.
Right.
That is what you are saying.
I think because they have not made any study at all. Thus, the term UPS encompasses a broad array of the torts, all of which involve economic injury brought by deceptive or wrongful conduct of the general trade under TPT and falsely representing that the goods are of a particular standard, quality, quantity, grade, type or model, keeping in view with the definition of explanation to section so-and-so of the Act. The term unfair trade practice, in addition to the word for the protection of the human, animal, plant, health, safety of the environment, finds place in section 16 of the Act of 2016 as one of the underlying considerations to the exercise powers under the Act of 2016. The term unfair trade practice in the context of 2016 can only refer in short to substandard products competing with the standard products and injuring the consumers of the standard product. The WTO agreement on the TBT, however, uses the word deceptive trade practices in the same context in TBT and so-and-so to achieve inter alia national security requirements, the prevention of the deceptive practices, protection of the human health, safety, animal, etc. The two sets of the people, namely consumers and other stakeholders, probably the person related to or incidental sought to be protected, revolve around the standard product and consumers in furtherance of the common object as stated in so-and-so. The right to formulate a measure consistent with the TBT under the Act of 2016 is pursuant to a purpose of premises as set out in the TBT of the Act of 2016. The permission to apply a measure has whether to further to interest to the consumers vis-a-vis the human health and consideration of environment impact and to curb the deceptive trade practice in TBT or unfair trade practices in the municipal law, in particular in the context of commercial interest. For the purpose of carrying out the provisions section 16-17 of the Act, no rules have been framed so as to create a legal framework to identify the items injuring the human, animal, plant, health, environment, validate the findings of the scientific evidences, adjudicate the cases. So this has not been done. There is no rules. Now, the Supreme Court in the case of so-and-so, in the context of the relationship between the GATE, WTO dumping and the section 9A of the custom tariff and rules has inter alia observed agenda. A conspectus of the aforesaid authorities would lead us to the following conclusion. Article 51C of the Constitution of India is a directive principle of state policy which states that the states shall endeavor to foster respect of international law and treaty obligations. As a result, the rules of international law which are not contrary to the domestic law are followed by courts in this country. This is a situation in which there is a international treaty to which India is not a signatory or general rules of international law are not made applicable. If it is a situation that if there happens to be a conflict between domestic law and international law, domestic law will prevail. In a situation where India is a signatory nation to the international law treaty and the statute is passed pursuant to the said treaty, is a legislative aid to the construction of the provisions of the statute. They are vague and ambiguous to have recourse to the terms of the treaty to resolve such ambiguity in favor of a meaning that is consistent with the provisions of the treaty. In a situation where India is a signatory nation to the international law and a statute is made in furtherance of such treaty, a purposive rather than a narrow literal construction of such a statute is preferred. The interpretation of such a statute should be consistent, construed on broad principles of the general acceptance rather than earlier domestic precedents, being intended to carry out the treaty obligation and not to be inconsistent with that. In a situation in which India is a signatory nation to the international treaty and a signature statute is made to enforce the treaty obligation, and there will be no difference between the language of such statute and corresponding provision of such treaty. The statute language should be construed in the same sense as that of the treaty. This is for the reason.
Just 1 second.
Right.
Yes, please.
My lord. The petitioner states that the appropriate central government for the purpose of BIS TBT is Secretary Ministry of Commerce.
Dr. In what context are you
So this was
referring
in
to
context of
Article
anti-dumping
51C?
duty. Anti-dumping duty, that was also in the terms of the GATT and the WTT.
All right.
So when the same in the loss was seen in the preamble, a statement of object is in the pursuance of the General Tariff Agreement and the GATT below. So when the Supreme Court said when they are the signatories, then they are bound to follow it.
So in that treaty, that restriction, unnecessary obstacles,
Milo.
that was there, correct?
Milo.
Unnecessary obstacles should not be there.
And the words etc. are to be construed in the line of the Milo to give effect to the GATT and the tariff.
Okay.
Now we'll also kindly see below. The petitioner states that the appropriate government, central government for the purpose of activity is Secretary Ministry of Commerce, who is also respondent 5 in the present dispute. To settle the dispute on who is the appropriate government for the purpose of Section 1617 of BIS Act, besides WTO Technical Barrier of Trade, the petitioner is attaching herewith the office memorandum that is so submitted by respondent number 1, 2, and 3 to respondent 5, wherein respondent 1 and 3 has entirely stated, paragraph 2 of the office memorandum, that CCPC does not administer any act rules under which a standard can be made mandatory. The proposed compulsory certificate panel is proposed under Section 16 of the Act of 2016. That chemicals has no power, Ministry of Chemicals. Paragraph 3 has entirely admitted, disclosed that Department of Commerce is the nodal agency in Government of India to deal with the issues on technical barriers on trade.
That recommendation was by Department
Chemicals.
of Chemicals.
Chemicals.
So therefore, it's without jurisdiction.
My lord. In the conspectus of the above facts and disclosures of the OM, the whole of the directions of the respondent number 3 to respondent number 4 is bad in law and exercise of powers that did not vest in the respondent 3, and thus vexatious. At the most, the actions of the respondent 3 are not statutory but merely recommendatory to impose, because respondent number 3 lacks any lawful authority to invoke Section 16 and 17 of the Act of 2016. Pursuant to the administrative directions of the Cabinet Secretary during 2017, inter alia, to curb and reduce imports vis-a-vis subsequent decisions of the Commerce and Industries Committee of Secretaries to enforce the import restrictions, the petitioner details the impugned policy decision having been taken already by the respondent. What remained thereafter was a mere formality to articulate and calibrate the policy so as to impose such decisions in the strict imports, and therefore to enable the proceedings of the respondents, formal and informal requests or applications were engineered and obtained by the respondent using the trade association of federations and so and so. Thereafter, again, my lord, in the next page,
Yes.
I have stated again about the Ministry of Commerce. Then, last paragraph, I have stated about the RTI reply,
Yes.
that there is no information. Now, I will also skip over page 18, my lord. Second paragraph. The two raw materials are generic molecular chemical product on which there are no two, and there can be no two different standards throughout the world. There are, however, standards on taste and criteria of conformity. There can be no other different generic formulation for the two products as aforesaid, though the criteria of conformity assessment may be have permissible tolerances of varying degrees of impurity and imperfections in the form of volatile contents of the standard of BIS or any other can be of standard of testing the product and not product by itself. The respondents have failed to apply their mind to verify the facts on conformity assessment statutory protocols prevailing in EU or other countries while recommending the mandatory BIS mark on the two raw materials imported by the petitioner, nor have they assigned or activated any categorical subdivision of their own protocols in the community assessment practices followed by the producer exporters in EU and other countries as to how they were insufficient and appropriate to achieve the purposes of the Act of 2016. As you also have seen in the date, that they must see that the standard which was prevailing there, whether that is in conformity or not. No, nothing, no exercise was undertaken by the authorities. Now, you also can see last paragraph, my lord. The purported decision of the expert committee is based on no legitimate expectable materials or evidence or test results which support the misconceived allegation that phenol and the melamine of industrial grade can be used or are used for pharmaceuticals or medicinal or human consumption purposes. The medicinal grade phenol is a drug included in the Indian Pharmacopoeia and is therefore covered by serial number 5A of the second schedule to the Drugs and Cosmetic Act. Use of the phenol in products of human consumption is regulated by the Drugs and Cosmetic Act so and not under the Act of 2016 or by BIS. Drugs comes under the domain of the Central Drugs and Standard Drug Organization and the Directorate General of Health Services, Ministry of Health and Family Welfare, Government of India, who is also a regulatory authority on drugs. In the premises, both drugs and pharmaceuticals have not been allocated under the allocation of business to the Department of Chemicals and Petrochemicals, and therefore what remains under jurisdiction and supervise the role of Department of Chemicals and Petrochemicals is phenol for industrial uses only, in respect of which the provisions of Act 2016 have no manner of application.
Yes.
Since industrial users are not consumers within the meaning of the term under the Consumers Protection Act, therefore, the purported notification laying down the BI standard for imposition of said goods, the license, so and so, I've said the this is not there. Thereafter, it is expressly submitted the paragraph 5.1 of the BI standard is a packaging standard as agreed to between the purchaser and the seller. The respondent authority have not demonstrated that existing packaging standard in VAG were insufficient, and in any case, the packaging standard being matter of buyer and the seller arrangement, the respondent authority cannot in such judgment to justify its arbitrary and illegal actions. The phenol is a liquid and is often transported in bulk vessels and ships carrying cargo for different other countries, also which are discharged at several ports in the transit to India, and once it is received at Indian ports in a bulk cargo, it is stored in the suitable storage tanks at ports within the custom bonded area. Such storage tanks also store the common tank, the phenol uploaded in India for re-exports or imports by the export-oriented units, or such imports that are made free on which BS regulations do not apply at all. The respondent authority have not visualized or applies mind to the fact that the vessel or the ship has to be marked, but that is never the mandate of the Act of 2016 or marking scheme, and thus the whole or import becomes impossible in bulk vessels owing to the supervening impossibility in such a scheme. In fact, what is necessary that the IS so-and-so is movement or transport of such hazardous substances in ISO tankers or transfer from the storage tanks at ports of entry in India within the custom barriers bonded area to the consumer industry in India and after its clearance. However, such rules do not and cannot apply outside India in access to those which are already in place under the ILO conventions in the exporting countries. The ILO Convention on Transport and Carriage of the Hazardous Substances is a complete code which Union of India has also accepted as ratifying party to the treaty on ILO, and thereby responsible in the Department of Chemicals has no jurisdiction and power to free and further compliant of the supply of phenol and melamine in India. The statement of the respondent that it is proposed to revise clause so-and-so as a hazardous material as it is readily absorbed through the skin muscular so-and-so, it is sought to be brought under the compulsory standard of BIS being related to health and environment. The petition submit that there are many 684 chemicals listed under the manufacture, storage, import of hazardous chemicals rules published by the Ministry of Environment and Forest about so-and-so, that details of rules in respect of 684 items identified as hazardous, and that includes phenol also as serial so-and-so. The Department of Chemical People noted to select just 41 out of which the whole list of 684 items to declare mandatory for BIS marking, and finally decided to do so respect of few of the 41 items only and declaring mandatory only respect to 41 items for the so-and-so. If safety of human health is the criteria underlying the mandatory BIS marking for industrial product without consumer interface, then the said respondent have an overreaching obligation to disclose why the import of crude oil, benzene and most dangerous input to make phenol and several other hazardous equipments have not attracted the attention of the said respondent as a corollary to the same issue so and so. Thereafter, my lord, I have referred to my lord, some other sections,
25.3.
my lord.
That's all right.
And I may take you also the last paragraph. The responding authority have also assigned the region of unfair trade to national security as one of the region. By unfair in common parlance, it is understood substandard or sunset. In the context of Gate,
Dr. Sarab, before you read this paragraph,
My
can
lord.
we go back to the recommendation once? That impugned recommendation. Is it there in your compilation?
Lord,
Wherever it's comfortable for you to refer.
my lord,
Page?
office memorandum at page 51, which I have shown to you also, my lord.
Page 50.
One the order, my lord.
No, the recommendation that you are challenged, that is not there.
The recommendation paper there, right?
That is not annexed.
And this is there, my lord.
That's at page 51 and 54 is compilation of convenience compilation.
51 is the office
Office
memorandum,
memorandum.
24th
This is not
January.
being challenged.
Correct, but before issuance of these notifications, there was a recommendation. Is that on record?
My lord, that is in the petition, my lord.
On page 9. Page
90
90.
of the writ petition?
Annexure 1, you will also can see the petition.
Lecture 1.
Page 71.
Page 71.
My lord.
Yes.
Where the list of chemicals is mentioned, my lord.
Yes.
Then page 79.
No, in this 71 is a meeting
Where the items have been mentioned that they,
proposed to be discussed
My lord.
for making them mandatory.
my lord.
And in this, phenol is in, at which serial number? 10. No, serial number 10 is something else.
No.
List of petrochemicals, list of chemicals.
Page 75.
Yes, page 75, phenol. So this is the first notification whereby phenol was proposed to be made
My lord,
mandatory,
my lord.
BIS mandatory.
No. But
No,
Intention.
correct. That's what. That's why I'm saying the first proposing. I use the word Mr.
There will
Gogol.
also see page 89, my lord.
Page 80.
9. 79 is again meeting my notes. Same item.
No, here suggestion views, if any, may be submitted.
My lord.
Now, pursuant to this, some suggestions
Yes.
views have been submitted.
My lord,
Correct.
I'm
Have you?
giving the, I'm giving the list.
Have your office dealt with the sequence of these events?
My lord, in the petition is there. I'm giving the page numbers. You will also see the representation which was there.
Because what I want, because for the facts, it has to come in sequence from here. You see how they have decided,
Absolutely.
so as to for this court to appreciate the argument that you are making.
Absolutely.
At the end of the day, I have to put it in the
Well,
facts
I'll do
of
one
this
thing-
case and
I will
test
do
it.
one thing, my lord, the additional, my lord, the facts. I will.
You can just
about
one
these facts.
page, the
My-
list of dates along with the
My,
pages.
I will do it. My lord.
Yes.
Page, you lost mechanism, page 90. My lord, it starts from page 89, minus of the meeting.
All right. 90. Yes.
And you'll also mechanically see, my lord, page 89 and 90, relevant
Yes.
part.
Yes. I have it. All right.
Para 5, you'll also mechanically see, my lord.
Para 5. HOCL in the written
Because in
submission.
that, my lord, Deepak Funnel was they make the submissions. Here, the another company is making submissions. and para 7, my lord.
Because why I wanted to have a look at these things to find out whether any discussion on those conditions have been there.
That's
Because
why
till now I'm not getting it.
My lord, I will prepare. My lord, there is nothing.
Correct, but then this court has to be fully
No,
satisfied.
I'm
That
telling
is why
you,
you point out those
I will remember
relevant.
2 pages.
Very
I will
good.
just.
We can go back to the written submission.
So I will just again one more page. My lord, page 91.
Page?
91 para 12.
Yes. Number 10.
12, my lord.
12. Yes. For proper utilization of natural resources and prefer to buy. This looks like that you want to promote the Indian, the local manufacturers
Yes. Which is not the object of the BIS market.
to buy locally manufactured phenol.
My lord, make in India, very good, my lord, everybody likes. The local domestic producers should increase, there is no doubt about it, but not by giving the undue profit to them and purchase it. No.
All right.
Making India is that, my lord, you establish more industrial units here so that the items are manufactured, a number of them, but not that one is suffering and they have installed a capacity of higher capacity. Now people are purchasing from outside, so we should be allowed to sell it at the prices as we like. That is not the intention of BIS. BIS is altogether a different thing.
It has to be in terms of section 16.
My lord, the scheme is mere unfettered practices, quality of the goods, and all those things.
All right.
My lord, the page 24,
Yes.
the second paragraph. The justification of national security is absurd. Firstly, because the goods in question are not prohibited under the foreign trade policy of the government of India, and secondly, the items are not such that would have any military or armament uses or poses any risk to war threat to the security of India. The petitioner submits that it is not a dispute that the Union of India can make a standard of products that has interface human health or safety under the specified conditions. What is in dispute is the abuse of such powers in the matter of and in the areas of industrial inputs or raw materials without any consumer interface as defined in this very act, and or to the extent such powers are exercised for illegitimate purposes and collateral gains solely to modify the conditions of competition in Indian market to benefit the vested interest without any demonstration as to how the existing practices were unsafe and harmful, and without any changes in force of BIS mark orders, the objective could not have been achieved. The conditions precedent to exercise the powers of the permission under the General Agreement of Tariffs and so. Then again, my lord, I am referring to the appellate order at page last paragraph, my lord,
Yes.
where the appellate order was there, where ITI application, it said, my lord, Cabinet Secretariat and the Department of Commerce had time to time emphasized the make BIS tender mandatory for the past number of years. A meeting of the Committee of Secretaries was held under the chairmanship of so-and-so. It was decided that all administrative ministries may ensure the pending technical regulations are exhibited and notified so-and-so. The minutes of the meeting held on under the chairmanship of so-and-so regarding making of standard mandatory for major chemicals, paragraph 3 of the minutes reached under. He mentioned that the list of chemicals indicated in the meeting notice have been prepared by Department of Commerce. These chemicals are imported in a huge quantity by India, and Committee of Secretaries in the meeting held on so-and-so decided that Administrative Ministry may ensure that technical regulations are notified for the chemicals under the BIS and so. My submission that when it is not coming under the Ministry of Chemicals, how the notification keeping the orders can be issued by the Ministry of Chemicals and not the Ministry of Commerce. Now, Lord, this is the last paragraph, my lord. Last but one paragraph. The notice of the meeting that is so-and-so with the subject reduction of excessive dependence on imports of chemicals and petrochemical sector regarding categorical in assertion to be here invoked. This was the subject, my lord. Excessive dependence on the import,
Yes.
which is not the criteria for the imposition of the BIS mark.
Yes.
And I will also, I may skip
The
over.
subject itself supports the contention that you are making.
My lord.
The subject itself supports the contention that you are
My lord.
bringing home.
Now I will also, my lord, again at page 29, the last paragraph I stated about the statement made by this intervener. Next page you'll also see.
30?
30.
Yes.
The petitioner submits that first of all, the said ground cannot be a ground for demanding imposition of the BIS mark as per the Provisional Act of 2016. And secondly, there was no shutdown of the factory of the manufacturing company. This was a bogus and false written assertion made by the respondent number 7, intervener before the respondent number 3, without any verification of the complaint by the respondent number 7. So to garner and invoke sympathy to administer the TBT measures as an emergency measures to concede and or grant relief contrary to the proclamation of the achieving of the capacity utilization of the of about 90% of the despite COVID-19, which would not have been possible if the factory was closed for a minimum of 3 months. Monthly GST returns, GSTR one return will testimony the fact that the factory was never shut down except for the routine maintenance during May 2019 for a period of 2 weeks. It is expressly submitted that the objective of the measures in the BIS mark is to regulate and ensure quality product available in the consumer market. However, neither the Act nor the other stated provisions authorizes or empower state authority or a government authority to try in the grab of achieving such objective. Act in the benefit of the domestic producers of the said goods, enabling them to capitalize and make undue profits, taking advantage of the creative shortage of the said essential raw materials to the detriment of the end users of the manufacturers of so and so. Now, we'll also see page 31, last paragraph below.
Yes.
There is rigidity and flexibility of the application of the measure that requires a registration by the foreign producer for a substantial amount of security deposit of USD 10,000 as a precondition to qualify for the license to export to India, instead of demonstration by the exporter or importer consumer at the port of entry amounts to arbitrary and unjustifiable. The strain on the goods that is otherwise compliant and the exceptions to under Article 20 of the GATT must not be based on the unjustifiable measures and deserve to be condemned inevitably on the basis of the TBT measures that does not embrace the unilateral approach to the TT system would be invalid under the chapter so and so. Last 32, last paragraph below. It is harsh reality that TBT measures have been invoked on commodities where there is a huge imbalance between domestic demand and supply, necessity import out to fulfill the supply gap. It is also an irrefutable fact on record that whenever against a whichever commodity the TBT matter has been invoked, the domestic producer prices have surged between 100% to 150% without any interference from the government, as if TBT is a profit booster measure for the domestic producers without even assessing the realizing the harmful effect on the downstream consumers and so and so.
This should be read as harmful effect.
Harmful it will be. The example of surge in the price of caustic soda, which has surged by 150%, the day the measure become operative, the story with all the other countries, commodities is no different. Caustic soda, whenever the BIS mark was there, it was increased by 150%. Now some of the judgments, my lord, at page 33. In Supreme Court in 1966, 33, C34, the chief function of the writ is to compare performance of the public duties prescribed by the statute and to keep subordinate tribunal and officers exercising public function within the limit of the jurisdiction. It follows therefore that in order to mandamus may issue to compel the authority to do something, it must be shown that there is a statute which imposes legal duty and every party has a legal right and to impose its performance. The court stated the same position in so and so. There is thus no doubt that the high courts in India, exercising the jurisdiction Article 226, have been power to issue writ of mandamus or writ of nature of mandamus for past orders and give necessary directions where the government or public authority has failed to exercise or wrongly exercise the discretion conferred upon it by the statute or the rule or policy decision of the government, or has exercised the discretion malafide or on the irrelevant considerations, or by ignoring the relevant considerations and materials of such manner as to frustrate the object of conferring such discretion or the policy for implementing for which discretion has been conferred. In all such cases and in any other fit and proper case, the High Court, in exercise of jurisdiction Article 26, issue writ of mandamus or writ of nature of mandamus, pass orders and give directions to compel the performance of the proper and lawful manner of the discretion conferred upon the government or the public authority, and in proper case, in order to prevent injustice resulting from the party concerned, the court may itself pass an order to directions which the government or the public authority should have passed or given properly so and so. From the aforesaid judgment, apex court is clear that writ of mandamus can be issued where authority has failed to exercise its discretion vested in it, or has exercised the discretion malafide or irrelevant consideration. The apex court again in so and so held that therefore it is clear that a writ of mandamus or direction in the nature of writ of mandamus is not to be withheld in exercise of power under Article 26 on mere technicalities. This is subject to the indispensable requirement having fulfilled. There must be public duty. While the duty may indeed arise from the statute ordinarily, the duty can also be imposed by the common charter, common law, custom, and even contact. The fact that the duty may have to be untable and must and missed around it cleared before the shape is unfolded may not be relieve the court of a duty to call out the public duty in a statute, and otherwise, if in the substance it exists. Equally, mandamus should also lie to an authority which has discretion, fails to exercise, and prefers to act under the dictation of some other authority. I am saying below that the authority was acting under the dictation of the domestic producer. It is by now settled that wherever policy decision is reflected in the statute rule pertains to the field of subordinate legislation, the same would be amenable to judicial review entirely on the ground of violative Article 14 of the Constitution. The judgment I given. While dictating the above term, the apex court held the High Court was not only correct when it opined that policy decision cannot be subject matter of judicial review. As such, it is clearly submitted that policy decision is not immune from judicial review if the said judicial review is arbitrary and violative Article of Constitution of India. Thereafter, my lord, I have in the page 36, I have given decisions of the culpable exercise of power. I am saying, my lord, that this power is a culpable exercise of powers because the object for which the power should have been exercised, it is not for that object, it has been given a color of the project. So I am not reading the judgments, my lord. Para 38, my lord, conclusion I have said. The present case, since the respondent authority are proceeding to make BIS marking on import of mineral so and so by exercising power Act of 2060, purportedly to achieve the aim and object of the Act of 2060, whereas from the preceding paragraph in the present submission it is clear that the real intent of the respondent authority making the mandatory BIS marking is to curtail and restrict import of mineral marking with the whole object of benefiting the domestic industry, which is nothing but a culpable exercise of powers.
Yes.
This is my written submission in court, and my lord, as you lordship desired, I give it 2 pages. So factual, nothing legal, my lord.
I'll post it for another date.
Right.
And
Let's say, Lordship, I will reply. Some
what reply?
small reply is required. Some clarification part I have to give.
I have heard the respondents.
So that's because, Lordship,
You have yourself called for that risk.
That is not.
Anyway,
That is
next
not.
on that day, whatever you have to say.
Lordship, I will some clarification should be required, Lordship, for proper identification of the issue. Otherwise, Lordship,
And in case you, Mr. Gogoi, you want to submit something in written, you can
not
do so.
require. Just I am point out the relevant provisions, Lordship, and I will explain
Why the
Why the-
need has come
why
for.
it has come and what is the purpose and what section 16 has
All
said.
right.
Only 3 things I will reply.
Very well.
And definition part, only 2 I have replied.
Only then I have to only what are the allegations, personal allegations
base. That's
All right.
Just 2 minutes.
Good, good.
Personal allegations on the basis of the records.
Yes, yes.
I have not said anything
We
outside.
respect that.
Date to Silia Teacher. No. 12. Next week I shall not be available. The week next I'm not sure. So to be on the safe side, I can have it fixed on the 12th of June. Is that alright?
Yes.
Because 1 week earlier I'm not sure, because that period it has not yet come, but looks like there will be a continuation wherever I'll be next week. 12th.
Mr. Sharma is my very close friend. Whatever I've said, I have not said. I have not said
It always stays in court. Nothing goes out of the court.
nothing out of court, inside the court also. It is not against Mr.
He's
Sharma.
always been very kind, brother. He's one of the stalwarts here.
No stalwarts. It is only against the case. So nothing. He should not take it.
And I always take it at that spirit.
Mr. Sharma has been smiling, so I don't think he has taken any offense to anything.
Never. Not for my learned. Yes.
And even if he takes him alone, I have at least that authority that I can say that you should not
Yes,
take it.
yes, of course. Ardent part fixed on
12th
12/6/2024 for further hearing. Oh,
And before that, I will prepare the small and I will send it to them also.
just the list of dates, how the matter was
Yes,
proceeded.
meetings and
That would
stuff.
be relevant for the
Only the
factual
factual part,
aspect.
not 2-3 pages, and I will send to.
and the relevant pages, because
Right.
I want to see what was the reasons, how.
In fact, that should have been incorporated. I'm sorry,
correct. That is important, because
and I have not gone into that.
no problem, Dr. Saraf.
I'm highly obliged. Always a pleasure to argue for.
All right. একেলগে ভালকে থৈ দিবা দেই।
Item 11.
এইটো ইয়াৰ লগত থাকিব। তোমাৰ এইখিনিও আছে নহয়। এইটো চব আছে। মেৰিয়াল গাঁও। এইখিনি একদম ভালকে হেৰি কৰি। Yes.
Wait, please, Manoj.
What is this?
Hello, this is a very old matter pertaining to item 11, Lordship. Item 11, I pay for little accommodation from our side, Lordship. We have today filed
No problem. When do you want it?
any day, Lordship. That's the Lordship convenient and my brother.
Next Tuesday? As prayed for by Mr. K. Gogoi, learned additional senior government advocate, which is not opposed by the petitioner, list this matter on
Next
Tuesday,
Tuesday.
28/5/20.
What is the first item in the hearing?
It's a 2013 matter. Automatically, it will be on the top. Today, because of the part heard matter,
No.
it's listed after that.
Very well. I'm obliged.
May it please your Lordship, I am appearing on behalf of Mr. Aspidas. He is suffering from diarrhea. So kindly adjourn this matter and fix any date
It is submitted by MS
as per
as so-and-so learned counsel for the petitioner that the arguing counsel, Mr.
Aspidas.
SP Das, is indisposed and accordingly seeks accommodation for today. Stop. Prayer allowed. List on next week.
Okay.
Item 13.
Your Lordship. Lordship, this matter may be taken up on 28 May if the conducting counsel is in another court for a part heard hearing.
Who is the conducting counsel?
P. Borua.
All right, Mr. Bora.
Yes,
As which matter? Hmm? 13. Oh, open. Oh. Sorry, I cannot take this matter.
let's
List
buy.
before any other bench acceptance.
Knowledge.
Item 14 to 18.
You are appearing for the petitioner?
Yes, my lord. Matter may be taken after 2, my lord.
Why, on the last occasion you were not there. So we are appearing now.
Yes.
Alright, then I'll post it next week. In view of non-appearance of, in view of no representation on behalf of the petitioner on the last occasion, comma, this court had directed listing of this matter today with the remark for dismissal. Stop. Today, when the matter is called, Mr. Your name?
S.A. Ahmed.
Mr. S.A. Ahmed, the learned counsel for the petitioner, is present. Stop. I'm listing this matter next week, Ms. Fukar. Anything you want to say? As such,
Behalf of SAM.
list this matter for admission.
On behalf of SMM.
This is all for hearing, ne? For hearing on next week. Date.
I am appearing for a standing company.
That's all right, Ms. Fukan.
Offline.
On an effective day, we shall record your name.
Yes.
Item 19. 35.
I appear for the respondent number 3.
None appears for the petitioner when the matter is called. Stop. Heard, Mr.
B. Roy.
P. Roy, Learned Counsel for respondent number
3.
3 and 4. And anybody else? Mr. Gogoi, are you there?
Yeah, no.
Who's there for 1 and 2? DRT. Okay, that's it, Lekha. In view of non-representation on behalf of the petitioner, this matter on the last occasion, comma, this matter was directed to be listed today, I so and so date, with the remark for dismissal. Stop. Today also, when the matter is called, with the remark for dismissal, comma, there has been no representation on behalf of the petitioner. As such, the writ petition stands dismissed for non-prosecution.
Obliged.
Item 20.
Please, your lordship. And the matter may fix at 2 lordship functionalities on legs and other codes.
All right, next week then. As prayed for by MS
H. Takuria.
S. Thakuria, Learned Counsel for the petitioner, list this matter